Hello and welcome. We have a very interesting and important and I think timely show. It's timely at least for many, many of you. You all probably know someone who is going through a divorce or thinking about going through a divorce or just gone through a divorce. So we're going to learn more about the process. I think there are so many new things happening in the world of divorce law, and my guest is someone who is wonderfully able to speak to all my questions, and I'm sure most of yours. My guest is Joani Moberg, who is a family law attorney. She's with Henschel Moberg, and she's downtown Minneapolis. She's had some wonderful honors in the last several years. You were listed as a Minnesota Rising Star in the world of lawyers from 2003 to 2013. And she made what's called the Minnesota Super Lawyers List in 2014 and was included in the Best Lawyers in America Family Law section, which was extremely impressive, I thought, Joani. What maybe impressed me the most, though, these are all great honors, was that Joani conducts judicial training for new judges in Hennepin County. Welcome, Joani.
Thank you, Mary.
Some people decide to not use an attorney. And as an attorney, I'm guessing you have some strong feelings about that. But what do you think of that approach? It's fairly common, I think.
It is common. I think for me, most of the people, obviously all the people I work with have chosen to have an attorney or are able to have an attorney, but I know from my judicial officer friends that probably at least half of the cases in family court don't have any lawyers in front of them. So it is very common, and that's understandable. Lawyers are expensive and not everyone can afford it. I think budgeting for a divorce is probably least fun thing I can think of to spend money on. But if you can have an attorney, I think it's a good idea. If I had a need for an attorney outside of the area that I'm a specialist in, and even inside the area I'm a specialist in, I would have one. But for people who can't afford one, there are a lot of options. The court websites have great forms and resources available. A lot of the counties, including Hennepin County, have self-help centers, so you can go in and spend some time meeting with a volunteer attorney or get some help with the forms that you need to have filled out. And then if you just want to pay for some limited services with attorneys, you could do that as well. You could just pay for a consultation and get information from an attorney. You could get referred to a good mediator, so at least the person who's helping you resolve your case can make sure you're answering all the questions that need to be answered. And some attorneys work on what's called a limited scope basis, so they might not help you with the full cadre of all your legal needs, but they could just help you do this one court appearance, or they could just help you draft paperwork. And so there are options out there in between full representation and no representation.
When you mentioned budgeting for a divorce, is there any ballpark number you can throw out in terms of cost of a divorce? Is there an average here in Minnesota?
I don't think so. That's a really hard. Clients ask me that all the time. And you could have a divorce if you settle it without very much help from your attorney, and your attorney just drafts the paperwork. That costs you a few $1,000s. If you have a divorce that lasts for a long time with complicated issues where you're hiring experts and you do a lot of litigation, it could cost you tens or even hundreds of thousands of dollars. So it really depends on your case.
And how about length of time when we're talking averages? Is there any kind of natural length of time that we can tell people?
Sure, I get that a lot too, because when people come in, they're in distress and they're hoping it would be over as fast as possible. And it's hard to say, because like with the money, there's a range. If you resolve your case quickly and you can draft an agreement, it could be over within months or even weeks. Or if it's really contentious and complicated, it could take a lot longer. But I think a good rule of thumb is that the courts have a goal for resolution of a year. So from the time your case is filed to the time that you have a judgment and decree in your divorce, the court's goal is to have that happen within a year. And they have a lot of pressure on the courts to move cases through to disposition that quickly. So that's a good rule of thumb. And that does seem like a long time to people to be mentally prepared for that. So I just tell them to take it one day at a time.
Good advice for any of us at any time, right?
Yep.
The process, kind of by nature, is adversarial, no matter what, I think. And yet, if you have children, you're going to have to be co-parenting for years and years. Do you have any advice as a family lawyer in terms of how people can make it less adversarial?
I think that's the challenge, and lawyers have a bad reputation because if you look at it cynically, we make our money off of conflict, but it's changed a lot. The legal system is set up in an adversarial way. If you think about juries and your traditional litigation cases, that model doesn't work so well with families, especially when you have kids. If everything goes according to plan, your children will outlive you. And so with the person who you were married to, you're not going to be married anymore, but you're going to be partners and co-parents for the rest of your lives, hopefully. So I'm very aware of that. I'm very aware that unlike a case where someone was hit by a car or a personal injury case, something like that, the people I'm working with have to have some sort of a relationship long after I'm gone from the scene. So I have a lot of goals that I work with on my clients, and even if that one's not a forefront for them because they're so caught up in the pain of the divorce, that's something that I'm thinking about and I counsel them on. And the good news is in Minnesota, I'm proud of our state and proud of our legal system because it's been very innovative. And so the court has recognized and the people in the court system have recognized that this model doesn't work. And in the last 15 years, we've seen huge transformations. When I first started practicing, it was routine where someone hired you and then you had to resolve temporary issues about who was going to stay in the house, what was the parenting schedule going to be, how was money going to be exchanged to pay all the bills. And we would almost always, very routinely, file papers with the court, go to court and have a hearing based on written statements of the parties. And as you can imagine, what one party would say was going on was almost night and day different from what the other party would say was going on. And that was very frustrating to the judges. And so now we have a different system where we have something called early case management. And that it started in the metro area, it spread across the state. It's actually a model for what other states are doing. And what it means is instead of judges getting involved in the case at the end when there's almost nothing they can do to fix a year of angst that's been happening between the parties, judges get involved very early on. Within a month of a case being filed, there's an initial hearing. It's informal, so nothing can be decided at that hearing that the parties don't agree on, but the court can sit down with the parties, memorialize in an order any agreements that have been reached so that they don't blow up later, identify the issues that are disputed, and then talk about a plan and a path to resolution. How can we exchange information, because you can't reach agreement if people don't have information, and what processes might be good for you to move forward to try to resolve your case. And then the court keeps track, and so they schedule phone conferences 2 months, 3 months down the road, so that if there are bumps in the road, they're identified early and they can be dealt with before they grow into something bigger than a bump. And that system has really changed how family law works in Minnesota.
Yes, that's very, very different from years ago when I was going through a divorce. Was this change, Joani, driven by judges or by attorneys or families, or how did it come to be here?
That's another thing I'm really proud of in Minnesota is there's a great collaborative relationship between the judges, the bench, and the lawyers, the bar. And so I think with early case management, that was largely driven by the judges. I don't remember specifically, but I think it was because they identified aspects of the system that needed to be changed, and they worked with the lawyers to make that happen. There have been other times with a program called early case management where that has been more lawyers saying, I think we could do this differently, at least with regard to financial early neutral evaluations. And so judges have approached lawyers and we've come up with solutions. Lawyers have approached judges and we've come up with solutions. There really is a commitment both ways to making the system work better, which makes it, what we do is really hard as lawyers and as judges. We see people, really good people, at their worst. And so it's rewarding that the professionals who are working in that context can work together in a respectful way to try to make this
important, isn't it?
To try to make the system work better. And I think it's never perfect, but I'm really proud of the job that we've done in Minnesota.
If a person does not have an attorney, can you still go to meet with the judge as a non-represented person?
Yes.
At that early meeting?
Yep, that first meeting, it's called an initial case management conference. So it's kind of a fancy word, but the idea is that it's this informal meeting that's going to talk about case management, and that is scheduled with, like, again, typically within a month of filing, whether you have an attorney or not.
When you have couples show up and say, I want a divorce, if they haven't done any counseling, is there any leverage you have to shoot them back to a counselor, or is that something attorneys even think about?
I think
because some people are spontaneously throwing in the towel. Others maybe should have gone to see you or another lawyer years ago.
I think that's maybe a little bit of a misperception. I had someone ask me early in my career, do you ever have a chance to save marriages? And I believe in marriage. I'm happily married. It's worked for me. I don't think when people take their vows of marriage, most of the time they take them lightly. And so I tell clients when they come and meet with me, I'm not a divorce advocate. I'm not here to promote divorce. I'm here to help you if you've decided you need a divorce. I'm a divorce lawyer, not a divorce advocate. Most of the time, Mary, when people come and see me, it's not something they take lightly. I'm honored that people come to my office and they share the most intimate, scary part of their life, that their relationship is troubled, that they've been abused, that they've made mistakes, that they think their marriage is done. This is maybe something they haven't talked to their parents about or their best friends about. And usually when they're brave enough to come and take that step, it's beyond the point where they can talk about saving the marriage. Oftentimes this is something they've grappled with for years and years and years, and it's beyond the point where they can try marriage counseling. But if I get a hint that they haven't made the decision, that they're not at peace with it, I tell them, you need to come to me when you're ready, and have you tried marriage counseling? If they say they want to go to marriage counseling but their spouse just won't do it, I coach them through how they could maybe have that conversation in a different way. And even if the marriage is done, individual counseling when you're going through a divorce process is almost always going to be helpful, especially if you have kids. You're trying to help your kids through this crisis at the same time that you're going through this crisis yourself. That's very difficult to pull off. And a lot of times, even if it's not marriage counseling to save the marriage, if people are going to be moving forward to be co-parents together, I tell people you can teach kids more about having a good marriage by having a good divorce than by having a bad marriage. So if your marriage was not functional and the kids saw you fighting and they were exposed to some difficult things, it's not too late. You can have a good divorce. And so have some sessions with a counselor for divorce counseling or uncoupling therapy. And it's too late to save the marriage, but at least you can talk about having a more functional relationship going forward. Get those things out in the open that bug you about each other and find a new way to deal with them, because you've got to go about the work of raising your kids.
I'm sure, a new idea for a lot of couples, but a very, very good one. In terms of the kids, custody becomes a big issue in a lot of divorces. And some of the laws are changing right now. And you said there's a new law coming into effect soon. Is it 2016, Joani?
Actually, this year, August 1st of 2015, there's a new law. It's kind of a rewrite or a reboot of the current law. So when custody is an emotional issue for people, obviously, most people would say their kids are one of the most important thing to them. And people get very invested in that issue. And then you combine that with the fact that in deciding custody and parenting issues, courts have a lot of discretion, so the outcomes are unpredictable, and that makes it an area that's ripe for lots of different outcomes and for conflict. For as long as I've been practicing, we've had the same law, which is that the custody and parenting time should be based on what's best for kids, which makes sense. And we've looked at 13 factors with 4 additional factors if joint custody was being sought. That is being rebooted, and those factors have been rewritten. A lot of the same concepts still apply. The overarching concept is that we focus on what's best for kids, but the statutes have been rewritten and simplified somewhat with an enhanced focus on kids. So for example, before there was a factor, the parents' positions, what do they want regarding custody? Well, that's not really very informative. If dad wants this and mom wants this, that doesn't really have much to do with what's best for the kids. So that factor, for example, is no longer present in the statute.
And do the kids at any point get to weigh in on this? Is there a certain age? I remember in one article I remember reading, it said 14 was an age that judges really did want the child to weigh in, or children. Is that true in Minnesota, or do we have?
I get that question all the time, regularly from clients. At what age does my kid get to decide? And the short
decide who I am with most of the time, right?
And the short answer is there is no such age. The statute says that, and the new statute says that one of the factors in considering the best interest of the child is a child's wishes, if the child is mature enough to express an informed preference. And so a 2, a 3-year-old, that's a non-issue.
Right.
But then there's a continuum. As the child gets older, the more that's going to be weighed. For some 8-year-olds, they still might not be mature enough. But for other 8-year-olds, they could really have a firm basis for why they want to do it. But a court is always going to examine if a child is saying something, why are they saying something? So parents focus in on that. But if a court is getting information that a child says, for example, I really need to have 50-50 custody, or I really need to have a 5-2-2-5 schedule. Most kids don't know what that means, and so it suggests they're being coached or influenced by a parent. Or if what the child wants, if they're very firm in it, but it's really not in their best interest, that factor's not going to weigh heavily. Practically speaking, the older a child gets, the more that has to be considered. So if my 8-year-old says I won't go to school, my 8-year-old is going to go to school. If my 8-year-old says I don't want to see dad today, I'm going to similarly press them on why they're saying they don't want to see dad. Is it because dad gave you a timeout and took your Wii away last time you were over there? Well, that's not a good reason for you to not go see your dad. And so in a mature relationship, I'm going to enforce that relationship with dad and send them. If I have a dysfunctional relationship with dad, I might say, that's great, you don't want to see your dad, he's a jerk, and I agree, and I'm going to go to court and make sure you don't see your dad. So courts are always wanting to understand the difference in those reactions. Now, developmentally, as a child gets older, they still don't rule the roost when they're 16. You still say you have to go to school, you still say you can't stay out until 2 in the morning, but it's getting harder, and developmentally they need to understand that even though they're not making the rules at 16 or 17, that they have to be starting to develop some autonomy. So it's challenging for parents and it's challenging for courts to balance having the child not feel like they're in charge and yet honoring the fact that they're getting closer to being an adult. And so the fact of the matter is most kids, once they're 16, 17, even 15, they're going to vote with their feet, and that's a challenge. And so in situations like that, if I have a client whose child won't come see them and they're that age, I say practically yes, there is a violation of a court order. You could call the police, but that's usually not going to be a good solution. We could go to court. The judge might look at me and say, how do you want me to force a 17-year-old to go see someone they don't want to see? Most of the time, what we do in those cases is we try to get them into family therapy as soon as possible when there's been any sort of an interruption in the relationship, because that's the best chance at resolving it and allowing people to move forward and still have the opportunity to have good relationships with both of their parents, which I think everyone agrees is ideal.
Thinking of what I want, what the child wants, one of the questions I didn't ask you earlier, but I want to throw it in now because I'm sure some people are wondering, if one person wants a divorce and the other doesn't, is it the no vote wins? I mean, is it always... Is that pretty clear?
It's heartbreaking. I mean, I say I'm not a divorce advocate and I don't push people, but the exception to that is if someone's in my office and they say, and this is happening a lot with boomers, the gray divorce is a common thing. People are getting divorced at 50 and 55 because they have long active retirements in front of them, and one spouse might think this is perfectly fine where the other spouse thinks I could have more. And so you have a lot of spouses who are upended and surprised by divorce. But if that person's in front of me, I have to just express sympathy and say, it's in Minnesota, if one person says there's an irreconcilable difference, they get a divorce, and if they've decided the process is going to move forward, even though you feel like the rug has been ripped out from underneath you, you don't have a choice. This process is going to move forward and we have to get you through it. It's sad, and I have a lot of sympathy for people in that position, but it only takes one to start a divorce.
That's what I thought, but it's important to hear it from you. Child support, that gets to be a sticky issue. And with our recent recession, with people changing jobs all the time, Is child support a guaranteed number if it's set by the court? Does the person who's paying the most need to make sure he or she can keep paying no matter what? How does that
Sure, there's two
work out?
There's two issues there. The initial determination of child support is actually pretty straightforward because Minnesota, as many states have developed guideline formulas, and so you can actually find the calculator on the Department of Human Services website, and it is a factor of the gross income of both of the parties, how much parenting time each of them has, and then you factor in what they pay for medical insurance as well, and it spits out a number for the components of child support. Child care is also an issue, so the court decides how child care expenses are going to be shared, how medical expenses are going to be shared, and then it sets an amount for basic support, which is meant to cover housing, food, clothing, those general things. A lot of times people reach agreement on how extracurricular activities are going to be shared too, but that's a separate issue. So with the guidelines, most of the time, and we have a lot of things to argue about and figure out, and so we kind of like that there's a guideline. So most of the time for courts and lawyers, that number that is spit out of the calculator is the number that it's going to be. But you have the right as a party to argue that there should be a deviation up or down. But once child support is set, that continues until there's a court order that says otherwise. So if you're the person who's paying, if you want to not pay that, or if you're the person who's receiving and you think you should be getting more, you have to go to court and bring a motion unless you go to mediation and reach an agreement. But it can always be changed, and the standard for that is if there's a substantial change of circumstances, first of all, and as a result of that, child support has become unreasonable and unfair, it can be changed. And usually that means if someone's income has gone way up or it's gone way down. Sometimes it means if some expenses have gone way up or way down. But we saw a lot of that, Mary, in the Great Recession, as you said, where people were downsized in their jobs, or they used to get a lot of bonuses and they don't get those anymore, or they lost their jobs, so they were laid off and they were getting unemployment income, and child support would then have to be revisited.
For a person or couple who have a lot of change in their life, this could be a pretty complicated thing, going back and forth to adjust that amount.
The child support? Mm-hmm. Yep. It can be.
Or alimony.
Right, and spousal maintenance is subject to the same standard. It can be challenging. People don't change it too often because it has to be a substantial change. So it's not, once child support is set, if someone, you can get cost of living adjustments, that's a separate issue. So you assume income goes up, and every year or two you can go in and bump it up a percentage or two as cost of living goes up. But it has to be a substantial change. So the court doesn't want you to be revisiting child support all the time. That's not an efficient thing for the system. And it does create conflict between parties. And so
substantial, Joani, meaning a 20% change?
In
is there any number?
Yep, in child support, it's that number. If it's a 20% change, that would be presumed to be a substantial change.
Okay, that's good to know. And what about support through college, with everyone urging kids to go to college and college costs zooming up? Is there any way that can be covered in the divorce decree?
We get that a lot too, because we all know as parents that when our kids graduate from high school, they don't go from needing us to not needing us.
Right.
They don't launch immediately and not need us. And so that is an issue. It's a concern for parents, but in family law, the court loses jurisdiction over the kids as soon as they graduate from high school for the purposes of support. So you could agree that this is what we're going to do for them in college. Most lawyers are going to be hesitant to put that in writing because it's a little scary to say something about college when you don't know for sure what your circumstances are going to be. I tell clients, you can take out loans for kids for college, but you can't take out loans for your retirement. So let's have you be the priority. But you can agree to that. It's not something that the court can order after the kids graduate from high school.
Okay, that's very good to know. We're getting the wind-up signal, and I'd love to have you give your website. So if people have more questions, they can search you out and search out more information.
Yep, absolutely. My website is www.henchelmoberg.com.
So henchelmoberg.com. Okay,
Yep.
good. We'll get that up there. Divorce is hard, as you've alluded to and said, on both parties. Are there any tips that you've used to help people get through the process, Joani? the year, as you said, feels long and daunting.
Sure. I tell people when they come to meet with me and they're daunted by that year, that they have to find people to rely on. They have to find ways to keep themselves healthy. I'm not a therapist. It would be a mistake to use me as a therapist, but I am there to take the burden off of you. And so it's overwhelming to look up and think a year is ahead of you. But you can focus on a day or two and put some blinders on. Don't look to the right. Don't look to the left. Don't look up too much if it's overwhelming. Just focus on it a day at a time. And if there's something that you really need to worry about, trust that I will tell you that. Other than that, try not to worry. That is terribly difficult advice to take, but it's important to try to find a way to keep your perspective.
When you talked earlier, and you just have a minute left, but about Minnesota being a leading state with some of the models you've discussed, is this taking off around the country, our use of neutrals and bringing the judge in early, et cetera?
Colorado has done a lot of observing of what happens in Minnesota. I know for certain, I think other states have as well. So that's something to be proud of.
Yeah, it's very, very interesting. Well, thank you so much for coming down. And I've learned a lot. I'm sure you as viewers have learned a lot. And again, her website is www.HenchelMoberg.com.
Thank you, Mary.
Yeah, thank you, Joani. It's great to have you on.
Thanks for having me.
Thank you for being with us. We'll be back again next week. Until then, have a good week.